Good evening, hello and welcome to the special broadcast. I'm Anusha Soni. The tussle between the government and the Supreme Court Collegium that continues unabated. The Law Minister has called the Collegium's move of disclosing government and IB's objections to the public a matter of serious concern. Now, this is about the appointment of certain judges to the Supreme Court. We remember there was a resolution that had come out in the public domain. From questioning the basic structure doctrine to an open attack on the present system of judicial appointments. This standoff perhaps has seen it all. But the last has not been said. While the government wants a say at the initial process of shortlisting and appointments that happens within the Collegium, with their representative a part of the present system, the critics call this the NJAC backdoor. Let's take this debate a little forward. From the usual verbal barbs and the vague assertions of reform of the present Collegium, is it open for the government to bring in another law on judicial appointments in this country? People on both sides of the debate agree that the system must be reformed and the basic structure of the Constitution, enshrined in the historic case of Nanda Bharti, must be preserved. But are the constitutional values or the basic structure of the Constitution secure only when judges appoint judges? Well, that's a bitter question that the government has been asking. The involvement of the government in judicial appointments was much greater before the second judge's case. The scenario is not unknown to India's constitutional history. On the biggest exclusive tonight, we discuss the way forward and what lies ahead.
जो रो का इंफॉर्मेशन, रो का इनपुट और आईबी का इनपुट्स को पब्लिक डोमेन में डालने का सवाल है, ये गंभीर विषय है।
Well, in the next 30 minutes, we'll have the leading voices from the bar and the bench joining us here on the broadcast. But before that, I want to take our viewers through the key points of conflict that we have seen between the Supreme Court Collegium and the Union Law Minister or the government of the day. Let's have a look at the key standoffs that we witnessed. Law Minister to CNN News 18, NJAC was a better option. He once again reignited that debate and said the manner in which the SC struck down NJAC was not correct. Justice Kaul on the bench, one of the judges at the Supreme Court, expresses displeasure over Rijuju's remarks. He made an oral observation. The Supreme Court Collegium on the 8th of December 2022 said that right now Collegium system is the law of the land, and they also asked the Attorney General to advise government over the legal position after these remarks had come in. On the 15th of December, you had the Law Minister once again who blamed the Collegium system for high pendency of cases and saying that if judges are busy deciding who are going to be the next judges, who's going to deal with the cases. While the Supreme Court Collegium reiterates 5 named to the Centre for appointment as judges 19th of January, you also had on the 22nd of January, once again, Jagdeep Dhankar questioning the basic structure doctrine. Even earlier, there were attacks that had come in from the Vice President about the basic structure doctrine. There were multiple questions that were raised about whether the manner in which the basic structure doctrine was used to strike down NJC was that a usurping of the powers of the executive? That was the question that was asked. Law Minister says that judges don't have to contest elections or face public scrutiny. Accountability of the judiciary and the present system of appointment of judges is one of the key questions. Law Minister has also questioned the Supreme Court for making sensitive information public. This pertains to the IB remark that we were just talking about when it comes to Collegium resolutions and how the resolution was framed. Well, let's take these questions to the experts who join us on the broadcast. I want to introduce former Law Minister, Mr. Ashwini Kumar, who is joining us on the broadcast. Sir, thank you so much for speaking to us. I want to understand from you, and more importantly, as far as the judicial appointments debate is concerned, Mr. Ashwini Kumar, sir, thank you so much for speaking to us. Thank you so much for joining us on the broadcast. I want to begin this debate by understanding from you, is the basic structure of the Constitution only secure when judges appoint judges? The government has put out a stinging criticism, but this basic structure doctrine, which has been the point of discussion for the last few days, or the Constitution, perhaps it needs reform in terms of judicial appointments. But is the system secure only when judges appoint judges? That's the simple question, sir.
I don't think that's a correct proposition. I have always believed, and I continue to believe, that the independence of the judiciary is by all accounts a part of the basic structure of the Constitution. But then to stretch the argument to say that the independence of the judiciary can be best subserved only when judges exclusively appoint judges is a flawed sequitur. I have never agreed with this. And in fact, when the NJAC was moved for the first time, I was the law minister, and it was done in consultation with the opposition. And we felt that as representatives of the people, the government of the day should have its input in the decision-making process. That was the purpose of the NJAC. But then the NJAC was nullified by the Supreme Court by striking down the amendment that introduced the NJAC. Therefore, the debate today should be whether an elected government of the day, and irrespective of the color of the government, irrespective of the party, which is the ruling party, should it have a say in the appointment process or not? I believe that the real issue is how do you appoint the best people as judges? It is about the quality of judges that will eventually ensure the independence of judiciary, and not necessarily the mode of appointment. And in any case, in the NJAC structure, as was proposed originally, and as is now sought to be broad-based, if the new NJAC structure is allowed to come in, it is not as if the judges will not have their say. They will have a very major say in the appointment of judges. But to have the law minister or anybody representing the government to give its inputs in the process per se does not detract from the ideal of an independent judiciary. That's the core issue today.
Yeah. So on that note, there was a suggestion that came from the government that at the initial stage of appointment process, when the names are shortlisted, is the government justified in seeking some kind of representation in the present collegium system? A suggestion that came from the law minister, is that tenable within the present collegium system?
Well, in the present scenario, the collegium system has been upheld to be the only mechanism by virtue of which you can go through with the appointment procedure for judges to the High Court and the Supreme Court. So to introduce a government representative in the present collegium system would, in my view, amount to doing indirectly what you cannot do directly. So I think this suggestion is not quite valid as per the existing legal regime. However, the right thing for the government to do would be to introduce an amendment to the Constitution, introduce a new NJAC structure, addressing some of the concerns that were expressed earlier by the Supreme Court while nullifying the NJAC structure, and then say that Parliament, in the exercise of its legislative function, deems it necessary to broad-base the system of appointment. And if that is done, I believe constitutionally speaking, and speaking for myself personally, it would be a perfectly valid thing to do. But to introduce now by a letter or by a suggestion a new person or a new institution into the collegium system will not stand the test of scrutiny as the system prevails today, and which has been sanctified by the Supreme Court decision in the NJAC case.
All right. Those are some very pertinent points, sir, that you've made. I thank you for your time and for joining us on the broadcast. I'll take all those points forward with the other esteemed guests who are joining us on the show. We have Mr. Aman Lekhi, who's a senior advocate at the Supreme Court of India and former ASG, joining us on the broadcast. We also have Mr. Vikas Singh, who's a senior advocate, who's also with us on the show. We also have Mr. Sanjay Ghosh, senior advocate, who's with us on the broadcast. Mr. Vikas Singh, I want to come to you first and taking a view from you. The basic structure of the Constitution, the case of Nanda Bharti case, has been discussed. I think there is a broad agreement on both the sides that basic structure of the Constitution, or the case of Nanda Bharti case, is here to stay and for good. It is one of the guiding cases as far as Indian democracy and its values are concerned. But the criticism from the government is that judges cannot appoint judges, and the Constitution cannot be secure only when the judicial appointments are completely in the control of the present collegium system. How do you see that criticism?
So, as far as the basic structure is concerned, I don't think it can be, set to specify with so much of clarity that judges should appoint judges. So that is definitely not the basic structure. But the basic structure definitely is that we should have an independent judiciary. And while deciding how to keep the judiciary independent, they have devised this collegium system.
Yeah.
If you ask me, the collegium system is the right way forward. And according to me, there are two ways there should be improvement in the collegium system. One is either they have a system of having a search committee which collates all the names together, which involves all the bar association, the government, and everybody. And the collegium itself can provide the criteria for selecting. So, for instance, they can say what should be the minimum income, what should be the age bracket, what should be the number of reported judgments, etc. And then take the view of the search committee. Search committee can also comment about the integrity, because the bar knows everybody. The bar association knows everybody. So they know which lawyer is indulging in malpractices, etc. If that is done, and then the collegium decides on that basis, I think that will be the best way forward. That will be my wish list. But if the government really is serious of relooking at this whole system, then the government should actually bring in a law where they give the veto power to the Chief Justice of India.
Interesting.
But at the same time, they become a part of the selection process. So the last time the NJAC failed only because the government had the veto power.
Yeah.
So if they give up the veto power, I'm sure the Supreme Court will not be able to strike down this law this time. I think and they will have a say in the appointment. So
yeah, because
to be available.
Mr. Ashwini Kumar was also making a similar suggestion that NJAC Part 2, it will have to preserve the primacy of the Chief Justice of India. Mr. Vikas Singh, second point to you before I go to my other guests. Is the government justified in seeking a government representation within the present system of collegium? Is that something tenable?
So according to me, his letter has not come on the public domain, but some of his tweets have come which indicate that he has not asked for being included in the collegium. He has asked for being made a part of the search committee, and which according to me is completely justified. And I say the Bar Association also should be part of the search committee. But if you really want my comment on his letter, then you should actually get this letter and send it to me, because I can't comment on something which is still being debated as to what he has actually said and what he has not said. But as I told you earlier, if he really wants to be part of the collegium, he'll have to bring in a new law. Yeah. And he can bring in a new law. And even judges have said so, that there is no bar for the government to bring in a new law. And the present system is faulty because judges say that we appoint people because we know the lawyers. That's where the fault comes in. They know the people who are close to them, or they know people who appear before them. They don't know the majority of the lawyers who are doing the drafting, who are doing the briefing of the seniors, and they are the real backbone of the and they are the real target group for being considered for elevation also. So if they are considered for elevation, they will be the best of the judges, because the ones who are appearing before you are really in the line for becoming senior advocates. And you require good senior advocates also in the profession. So if you start elevating everybody who's in line to become a senior advocate, there'll be a time when there'll be hardly any good senior advocates in the profession. So they are not getting to the target group at all. There is no effort to get to the target group. And that is where my problem is.
Interesting you make those comments. Let me take that forward to Mr. Sanjay Ghosh as well, who's with us on the broadcast. Mr. Ghosh, NJAC Part 2, is that an option before the government? When this entire standoff is building between the Union government and the Supreme Court Collegium, is this a precursor to the government willing to get yet another law on judicial appointments? And there comes a very interesting suggestion from Mr. Vikas Singh, who says that this time, if the law, NJAC Part 2, presuming it's coming, preserves the primacy of the Chief Justice of India, then it will become very difficult for any court or Supreme Court to strike it down.
The whole conversation is proceeding on the assumption that the government as of date has no say, and it's seeking a say in the whole process. Now, anyone who is an insider in the process, you don't have to be a big insider. Anyone who's a lawyer practicing in the courts actively will tell you that informally that already happens. Now, a name of a High Court judge originates from the High Courts and then travels to the Supreme Court. Now, at the stage of the High Court Collegium considering these names, already inputs come from various sources. As Mr. Vikas Singh is saying, the Bar Association's the presidents forward names, senior advocates also give their suggestions, and including the government and the government law officers give their suggestions. Now, what the law minister is saying, and again, I agree with Mr. Vikas Singh, unless we have the letter in the public domain, we can't speculate. But what he's saying is that he wants a member in the search committee as per the memorandum of procedure.
Yeah.
Now, that also is fine as long as that membership of the search committee is not used to completely, sabotage the process or to delay the process. So as long as you are part of it, it expedites the process, it brings a formality to what already is informally happening, I have no objection. But if that, if you formalize it and then you have a paralysis like you have now, then we have dangerous times ahead.
Mr. Ghosh, before I go to Mr. Lekhi, this great degree of informality in the judicial appointment process, when you said that, you have to be a great insider to know how much say a government really has. In the interest of the larger public, in the larger public interest, is it not fair that there has to be some degree of streamlining that should happen of this process, whether by way of reforms or through a resolution? Mr. Ghosh, if you can hear me. All right. I think I've lost that audio with Mr. Sanjay Ghosh. I'll fix that. Mr. Aman Lekhi, coming to you. The manner in which the Supreme Court had put out the resolution of appointment of Saurabh Kirpal and other judges and making those objections by the IB and the union government public. Clearly, the law minister didn't like it. He wasn't supposed to like it. But he says it's a serious violation. How do you see it?
Well, the government invited it. The objection was opacity. The Supreme Court couldn't come in this interview and explain its position because the objection was opacity. The Supreme Court was transparent. The government invited this particular situation, so I don't think the government has anything to be complaining about, firstly. Secondly, what is very important is the memorandum of procedure. No one is talking about the memorandum of procedure. Please understand, there are various methods of appointment. It can be exclusively by the executive. It can be exclusively by the judiciary. It can be judicial council. It can be election. These are various ways all over the world, which is where it happens. What the objection here is, it is by judges alone. This is a nuanced objection over here. It's not by judges alone because there is an interactive process which in some way involves the government too in this entire exercise. It's not as if the judges are in fact only the entity which is appointing, because the recommendation goes to the government. The government has got the right to return the recommendation. The court the judges have to consider it, send it back. So it is an interactive process wherein the agencies in fact confer with each other. So it's not judges appointing judges only. So it's not typically that particular system. It's not typically the executive appointing. It's not typically the judges appointing. The electoral process is out. Judicial council, I'm not for the time being concerned with. The problem here is who has to have primacy. Now, Vikas said if the government agrees that the court has got primacy, there's no problem. But the government will never agree. In fact, the whole problem here is who has primacy. Even right now, the question is primacy. So that particular suggestion is contemplating a situation which is impossible to come about. I personally feel the way forward is finalizing, and this is precisely what the law minister should be doing. And I got serious objection in the manner in which he comments, because these are serious issues which require a lot of restraint and prescience insofar as suggestion is concerned. If you are rather crude or callow in the manner in which you approach, then you muddy the discourse altogether so as not to address the point, which is where he's at fault. The method forward is that as far as the issue with the memorandum is, the government is insisting that on national security, it's got the right to say no. Now, we have to have a meeting ground on that basis that national security by itself cannot be a talisman unless they have cause, which can in fact be made explicit to the court, in which event the court may be justified in withdrawing the recommendation. At the same time, the court should not be chary on broad basing this particular exercise. So there can be other entities which can actually suggest to the judges that who are the possible candidates, and there has to be a method by which the judges will actually make it transparent as to who can at some point make the recommendation and which recommendation will move forward. In that event, the two basic objections to this particular approach will go. One, that it's not broad-based, as Vikas is saying, and two, it does not subordinate the judges to the executives. That it will be handled by a proper modification of the memorandum of procedure. Here I come to the third and the most vital point. If you began with what was revealed by the Supreme Court, not revealed by the Supreme Court, this should have been in public domain. There's nothing wrong in this. What you would find is that the objection is not to competency. The objection is not to the fact that this is an elite group. The objection is not that the person is the son of a judge or all the thing that goes. The objection is A, ideology, B, political affiliation. Now, as for the ideology and political affiliation,
Mr. Lekhi, will you allow me one interjection to be the devil's advocate here? There were those 2 or 3 resolutions that had reasoning in terms of why the name is being reiterated. In all fairness, isn't the Supreme Court Collegium also cherry-picking the resolutions in which it wants to reason their resolution? Because mostly these Collegium resolutions are 3 or 4-page resolutions which come out. We never know the names as to why they are rejected, accepted or reasserted. So in that way, it's not a uniform practice that has been adopted by the Supreme Court Collegium.
You see, as I said, this was prompted by the way in which the discourse was structured. The suggestion was that the manner in which the court is functioning is death knell of democracy. Now, because death knell of democracy, there was an upsurge of opinion against the judges. Now, that will affect the credibility of the institution. Now, until the institution speaks up, and which way will the institution speak? As I said in the beginning, no judge will come to this TV show to express the point of view. Absolutely. They can only speak to the record. Point is, to the extent the records demonstrate, the objections have got nothing to do with the issues which the law minister is flagging. Because the flagging by the law minister is the fact that this is, so far as the selection is concerned, it is narrow. It is supposed to in some way privilege certain interests. And it is contrary to national interest. What I'm saying is that the objection the government, as has been made apparent, because the government hasn't disowned the fact that these are the objections, as has been made apparent, do not deal with these particular issues. So it's not death knell of democracy.
No, you're right. You're right in pointing out that when it comes to Saurabh Kirpal or the other judges, the arguments of the government was not on the merits. Mr. Ghosh also has a point to make. Mr. Ghosh, please go ahead.
Yes, you must keep in mind that, we don't have the American system where the Judiciary Committee of the Senate, grills the candidate and everything comes out, all the dirt comes out, right? Now, here the advocates are giving their names for consent to be made judges. Now, in the process, the government now obtains this information from the IB. Often this is anecdotal information. For example, a judge in the Delhi High Court as a lawyer, he was a teetotaler and his friends used to call him boozer as a joke. And his appointment was delayed by 6 years because the IB reported that he must be a drunkard because his name is Boozer. So now in this process, when you have this kind of anecdotal, information being used by the IB to give some inputs. Now, if the Collegium is openly going to write about this is the reason and this is the reason why we are rejecting the candidate without even giving the candidate an opportunity to, explain his part or her part of the whole deal, then it might be unfair because, we are dealing with a semi-transparent process. So you must keep in mind that if it becomes too transparent, then, every lawyer will think twice before giving his name up for considering for judgeship because God knows what will be made up in his back. And then it will be part of a public collegium minutes and circulating on WhatsApp all over the nation. So you must keep that fact also in mind.
No, that's interesting, Sanjay, what you say. But I also want to know from you, Mr. Ghosh, that you talk about American system and how, the candidates are grilled and all the dirt comes out in the open. You have to, answer all the questions. There's a great degree of accountability. But if this process of reasoning does not begin, whether by the government or by the Supreme Court Collegium, we will continue to have this great degree of informality when it comes to judicial appointments. Mr. Lekhi very rightly said that there is a memorandum of procedure, but it is so vague in nature, the manner in which the process goes forward. There is no checks and balances, there is no accountability, a system of lobbying per se that exists. That shouldn't exist in world's largest democracy. We must have a better way of appointment of our judges. Mr. Ghosh.
I fully agree with you. When it comes to other people, the Supreme Court says that sunlight is the best disinfectant. But when it comes to itself, it follows the kind of a papal system, how the Pope is elected in a secret chamber and you have white smoke and black smoke. So I absolutely agree with you. And, I am in a dhobi ka kutta kind of position where I don't believe the primacy should either be with the judges or it should be with the executive. Now, to that extent, I did support and I do support an NJAC kind of situation. But here, the primacy, there should be a balance and the third party should be, and of course, the NJAC proposed that, a legal jurist or a sectoral expert. But here also, we must be cautious. Legal jurist should not be a senior advocate or a retired judge who has his own son and daughter to promote. So, we actually need a third kind of person, either the consumer of justice or a legal activist or a legal jurist who will bring in the balance and the third perspective to this executive versus judiciary battle. And I agree with you. At the end of the day, this process cannot be so, so opaque. And there has to be some kind of objectivity in this process. There has to be some kind of accountability in the process. You see, the judiciary is the only unelected wing of government, and the Constitution contemplated two checks. Check at the time of appointment, that is appointment by the political executive, and check at the point of removal, that is impeachment by the legislature. What the Supreme Court has done, it is usurped, with greatest respect. By judge-made law, it has taken away the power of appointment by saying collegium in the judge's case.
All right.
When it comes to reviewing even impeachment, in Ramaswamy's case, it says, even if you impeach a judge, the judge can file a case in the Supreme Court and we can sit in judicial side and decide whether that impeachment is right or wrong. So Supreme Court has become like the completely, unaccountable at a point of appointment and point of removal. Therefore, there has to be a check. But at the same time, the current, what we are seeing in the last 6 years, this kind of war between the executive and the judiciary is not healthy for the nation. So I'm very happy the law minister has disclosed.
And Mr. Ghosh, I believe this is a power tussle between the Supreme Court Collegium and the government of the day, and we must bring in public interest here. Mr. Lekhi, would you agree with all the criticisms that Mr. Ghosh so candidly made when it comes to the Supreme Court Collegium, the process of appointment of judges, and how this entire system post the second and the third judge's case has really evolved in this country in the last 20 to 25 years?
Well, you can't have any system which is perfect. Every system will have its flaws. I fail to understand actually part of the comment, because we want opacity, we want transparency. We can't have both opacity and transparency. The question is always of degree. To what extent there has to be revelation, that has to come to the business wisdom of the entities concerned. The point is, whether we like it or not, today we have a collegium system. That is the law. And as the government is concerned, the government is bound by the law. We don't have letters altering the law. If we want to change the law, there's a method. What the law minister is saying, the parliament is supreme. No, parliament is not supreme. He simultaneously says the constitution is supreme. So he's rather confused about who is supreme. If the constitution is supreme, in that way, the plenary power of the parliament is limited by the constitution. What the constitution is will be declared by the court. Whether the law minister likes it or not, the provisions of the constitution have been interpreted, and they have been interpreted to justify a system which is in place. If you got a problem with it, alter the law. You cannot simply say, okay, I don't like the law and we have to in some way work around it. You can't work around it, you have to work within it.
Absolutely.
Now, because you have to work within it, that's where the memorandum procedure comes in. As long as there is no law, the question of primacy resting with the court is uncontested. So the primacy is with the court. Whether you like it or not, the primacy is the court. The question is, how do you work it? You work it through the memorandum of procedure, and there comes the sagacity of those involved. Now, that sagacity requires restraint. And restraint would warrant the law minister to actually take all the parties along. The manner in which, the aggressive manner in which it is going, it puts the executive and loggerheads with the judiciary. You cannot possibly fight. You cannot possibly fight getting the particular outcome. As I said, there has to be, the court has to work, the judges have to work with the government. The government must not insist upon having primacy, because that is not the law. As far as the broad basing is concerned, there may be a secretariat, but the broad basing would rest with the judges only. Whether we like it or not, the change suggested by the government was substituting the collegium with the body. The search cum selection committee is outside the constitutional scheme as it avails today. So they cannot have a search cum selection committee outside the constitution, which is as declared by the Supreme Court. Yes. But nevertheless, what the court should do, the judges should do, broad base it, invite, as Vikas said, invite names of lawyers, etc., associate the Bar Association, associate other judges, but the decision will remain with the collegium, because that is the law. So if the government gives up the primacy and the collegium broad bases this particular exercise, this being a collaborative exercise, a nice gel of all the competing mechanism which is there, I don't see there's a problem. And the problem would be whatever the system, the system, there'll always be favorites. You can't ever have a system. You have another system.
You rightly said, Mr. Lekhi, that there is no system which is perfect, but striving for perfection especially when it comes to judicial appointments, I believe is the need of the hour. And with lawyers like you, Mr. Ghosh, on at the bar, I think there is so much scope for voices to come from within as to how this entire system can be made more transparent and accountable. As I said earlier, so much has been said between the government and the judiciary as far as judicial appointments is concerned, but the last has not been said. Will the government bring in another law? Will there be systemic changes to judicial appointments? Perhaps the time will tell. Well, with that, it's a wrap. I thank you all for joining us on the broadcast. Moving on, my colleague Shivani Gupta joins you with Plain Speak.